Peço imensa desculpa.
Vamos começar.
Sim, sim.
So, good afternoon, ladies and gentlemen. Dr. Rui Cunha, President of the Rui Cunha Foundation. So today we have a very interesting and important topic for our debate for this session at the Rui Cunha Foundation, which is the European Union's Common Commercial Policy after Lisbon. So after the Treaty of Lisbon, there were new elements added to the definition and the management of the common commercial policy. And I'm sure that our speakers will talk about it, as well as the significance of the commercial policy, common commercial policy, which after Lisbon became also part of the external dimension of the EU. So today we have with us Professor Catherine Titi from the Centre National de Recherche Scientifique in Paris, right? Or, okay, somewhere, France, okay.
It's a bit complicated because they ask for work for the French National Center for Scientific Research. Our actual place of work is a university, and my university is in Dijon.
Okay.
So my employer is based in Paris, but I'm based in Dijon.
Okay, good for you. And also Professor Fernando Simões from the University of Macau. So I will start by giving the floor to Professor Catherine Titi. Please start your presentation.
Thank you very much. And I would also like to thank the organizers for inviting me here. And I would also like to thank Fernando, who has had a very important role in my invitation. So for, I think, the next half hour, I will try and give an overview of the European Union's investment policy and the implications of this policy for international investment law. So in 2009, with the Treaty of Lisbon, the words foreign direct investment were added to Article 207 of the Treaty on the Functioning of the European Union, which defines what is covered by the European Union's common commercial policy. So with the Treaty of Lisbon, foreign direct investment passed from, as a competence, the competence of a foreign direct investment passed from the member states to the European Union. And that means that the European Union, since 2009, has exclusive competence to conclude treaties that cover foreign direct investment, at least foreign direct investment only. A big debate started after the Treaty of Lisbon, and the debate concerned whether, in fact, the European Union could conclude investment agreements on its own, or whether it needed participation of the member states. So investment agreements are treaties that protect foreign investors, and they typically don't distinguish between different types of investment. So an investment treaty does not generally protect only foreign direct investment, but most often it also protects other rights such as portfolio investments, intellectual property rights, and so on. So while the competence passed from the member states to the Union for foreign direct investment, the European treaties are silent on what happened to the competence, for instance, on portfolio investment. And so the member states claimed that the competence of the European Union for the conclusion of investment agreements was mixed, so that the European Union did not have and does not have the member states claimed exclusive competence over the conclusion of investment agreements, simply because investment agreements do not only cover foreign direct investment, for which the Union has exclusive competence, but also other types of investment. We have, as it was pointed out to me, we have now almost 10 years that the competence has passed, and we still don't know if the competence for the conclusion of investment agreements, so for the conclusion of the treaty between the EU and China, for TTIP and so on, whether it is an exclusive competence or whether it is a mixed competence. And at this moment, we have an opinion of the Advocate General of the Court of Justice of the European Union. The Advocate General considers that the competence is mixed. This concerns the treaty between the EU and Singapore that is waiting for the decision of the court before it will be signed. For CETA, so CETA is the treaty between the EU and Canada. The European Commission has said that it will not insist on the competence being exclusive, but it will accept to sign the treaty as mixed. That does not mean that the European Union accepts that the competence is mixed, but it simply does not want to delay conclusion of the treaty. It did not want to delay conclusion of the treaty, and so it has accepted this. So one of the big questions in the exercise of the Union's competence over foreign direct investment agreements is whether the competence belongs exclusively to the European Union or whether the European Union needs the member states to conclude agreements. The rationale behind this transfer of competence was in fact to allow the European Union to conclude investment agreements more easily and more efficiently without necessarily, I believe that was the initial intention, without necessarily having to wait for 28 or 27 ratifications in the member states. But for the time being, we are waiting to find out what is going to be decided. Another important element in the new status since the Treaty of Lisbon is the increased role of the Parliament. So the European Parliament now has the right to be immediately and fully informed about investment negotiations, and it also has, very importantly, the right to consent to the agreements. That means it has a veto right. If the European Parliament doesn't like an investment agreement, it can block the investment agreement. And this is important in the exercise of the European Union's policy because the Parliament has a strong social agenda. The Parliament has been insisting on the protection of human rights, protection of the environment, and so on. And all these considerations need to be taken into account, and they are actually being taken into account by the Commission. The Commission is the negotiator, in reality, of the investment treaties, and so there are constant exchanges between the Commission and the Parliament, and generally the Commission is aware of the Parliament's wishes and it takes them into account. And the passing of the competence from the Member States to the European Union, whatever the scope of the competence, whether the European Union is going to sign the treaties entirely on its own or whether it's going to sign the treaties with the Member States. So this transfer of competence had also an impact on the actual content of the investment agreements that are being signed. So until 2009, Member States were signing bilateral investment treaties, and by bilateral investment treaties we generally refer to investment agreements that cover, at least EU member state bilateral investment treaties cover the post-establishment phase. That means EU member state investment agreements protect investments once they have been established in a foreign country. So if there is a treaty between, let's say, Germany and Mozambique, this treaty would protect, I haven't looked at the actual treaty, but in principle this treaty would protect, for instance, German investments once they would have been made in Mozambique, but it would not protect prospective investments. So if a German investor would want to go to Mozambique, there would be no guarantee that this investor, for instance, would be treated in the same manner as local investors in Mozambique, or there would be no other guarantees. So until the Treaty of Lisbon, the European Union still regulated market access, which is the stage before actually the investment has been established in the foreign country. And member states had the competence for the conclusion of treaties that covered the post-establishment phase. So once the investment was in the foreign country. With the Treaty of Lisbon and with the new treaties, the European Union combines the two phases. So the European Union that would, until now, conclude free trade agreements that would give market access will or has already incorporated this aspect in its new investment agreements. And it also now, so essentially combines EU free trade agreements that it had the competence to conclude even before Lisbon, and post-establishment protections that were generally found in EU member state bilateral investment treaties. So the content of the new agreements is broader than the content of agreements that we had until the Treaty of Lisbon, when the competence in a way was split between the EU and the member states. This also had an impact on the considerations that the European Union has, that it takes into account for the agreements, because the new agreements, so CETA, TTIP, they will give, well, CETA gives, and TTIP will presumably give protection during the establishment phase. That means they're more intrusive as agreements, because not only they protect investments once they have been established in the other country or in the other economy, but they also give generally national treatment and most favored nation treatment to prospective investors. So that means that if a Canadian investor will want to invest in an EU country on the basis of CETA, the Canadian investor will have the same treatment as an EU member state investor. And so the fact that the new agreements are more intrusive also means that there are more safeguards that are included when compared to the old EU member state BITs, whose scope was much more limited. And there are two important elements in the content of the EU's investment agreements that are probably worth noting. One concerns the substantive protections, and the other concerns the procedural protections. So traditional bilateral investment treaties give access, give a number of protections for the investment. So in case of expropriation, they allow the investor to be compensated. If the host state has promised the investor that it will give it a license or a permit, and the investor goes to the foreign country, builds a factory and so on, and then the state refuses to give the investor the permit, then the investment treaty is violated, because in fact the investment treaty protects the legitimate expectations of investors. So if the host state has promised something to the investor, then it has to do it on the basis of the investment treaty. Investment treaties allow investors to freely transfer the profit that they have made on their investment from the foreign country to their home state or anywhere else they would like. The new investment agreements continue to give these protections, but they are more cognizant of the host state's interest in protecting also other elements, such as protecting the environment or protecting public health. And an example of that would be an example of why a host state would want to protect public health and why an investment treaty could interfere with it would be, for example, the Philip Morris case that I'm sure you all know. So in Philip Morris, a big tobacco company, started two claims, one against Uruguay and one against Australia, because these two countries passed anti-tobacco legislation. And this legislation, so in Australia it was the plain cigarette packaging, so that the cigarette packaging would have these horrible pictures, but at the same time it would not have the logo of the company. So the logo disappears, and instead the name remains there, but there is no logo, and the logo is a distinctive element of a company. So Philip Morris said that this was expropriation of its intellectual property rights. Now, Australia and Uruguay passed such legislation in order to protect public health. So this is a case, this is just an example of a case where a state may have interests that are different from the interests of investors, and this for legitimate reasons. These cases, they have both been decided in favor of the state, by the way. So in the Philip Morris versus Australia case was rejected at jurisdiction, and Philip Morris versus Uruguay was rejected at merits. So the new EU investment treaties take into account that a state may have an interest in protecting the public interest. And so they include exceptions that, although on the one hand they give investment protections, on the other hand they say, but the state can take such and such measures for the protection of public health, the protection of the environment, and so on, without violating the treaty, so without having to compensate a foreign investor. The other and the most innovative aspect of EU investment agreements is the creation of an international investment court. Now, we don't actually have an international investment court at this stage, but we have the provisions in CETA. CETA is not into force yet. The EU has made a proposal for a court in TTIP, and it is currently negotiating. It is speaking with Canada, EU and Canadian negotiators, and they're trying to convince other countries and international organizations to see how they could create a multilateral, a single investment court. Now, why is this innovative? Investment agreements until now, they give access to investment arbitration. And investment arbitration it comes from commercial arbitration, but we should also have in mind that we also have interstate arbitration. So it is not arbitration itself is not necessarily incompatible with public law. But the way the system works so far is that when there is a dispute, so an investor has a dispute with a host state, the investor will find an arbitrator, the host state will find another arbitrator, and the two co-arbitrators will select the president. So this is dispute resolution outside the court system. This is international dispute resolution, but it is not by professional judges. At the same time, it should be said that investment arbitrators are generally very highly qualified individuals. They they several times have been judges at the International Court of Justice, for instance. So it is not just anyone who becomes an investment arbitrator, but the fact remains that it is a system where the parties have autonomy. They can choose who is going to be their arbitrator. So the EU proposal is very different because it proposes a court. So it proposes that this private system of dispute resolution, private in quotation marks, should be replaced by a public system where the adjudicators are not nominated by the investor and by the state, so by the disputing parties, but they should be there in advance, and they should sit on a case on the basis of a rotation, and so it is a radically different system. But the EU proposal is also different because it is trying to target some of the criticisms that have been leveled at investment arbitration. And I would like to stress that these improvements that the European Union is bringing about could also be used to reform investment arbitration. So one thing is we could, looking ahead, we could have an investment court, but we could also look at introducing some of the improvements in investment arbitration. And I should also say that things are not necessarily black and white, and something that one person may consider an improvement, someone else is going to consider a deterioration of a situation. So some of the innovations that the new system introduces is an appellate mechanism. In the current system of investment arbitration, we only have let's say a first level tribunal deciding. If the if the dispute is adjudicated under the CRED system, CRED is the International Center for Settlement of Disputes that belongs to the World Bank. So if we have a dispute under CRED, under the CRED Convention, most particularly, we have a first-level tribunal, and then if one of the parties is unhappy with the decision, they have access to annulment. But annulment is not appeal. Annulment is very limited. The tribunal cannot really review, so the annulment committee cannot review the tribunal's decision for legal correctness, for instance. It can only do so if it can only review the first instance decision for manifest excess of powers, whatever that means, or in case there was corruption of the tribunal, or in case there was a problem with the constitution of the tribunal. So there is a, let's say, minimal review which does not go into the facts, which does not go into the legal correctness of the decision. If we have a decision outside the CRED system, we can have set aside or annulment proceedings at national courts at the seat of arbitration. But again, there is no way to look at the legal correctness of the decision. So one of the big innovations of the EU proposal is that it creates an appellate mechanism so that if there are problems with if there are problems of a certain level with the initial tribunal decision, then there can be an effective control of these decisions. Then there are other smaller improvements, which are, for instance, we have, of course, transparency, but Fernando is going to talk about transparency. We have the introduction of the loser pays principle. So in investment arbitration, the average costs are about, I think in 2013, it's 10 million US dollars, the cost of an average procedure in investment arbitration. The cost is very high, and the real bulk of this money goes to the lawyers. So this is essentially the legal fees, and then there's a very small amount that goes to the arbitral institution and to arbitrators. Arbitrators are very well paid, but in reality, the money goes to the lawyers, and these are cases that can last years and so on, and they do last years. I don't have the percentages or the exact amount, but an average procedure would probably last about 4 years. So when there is at the end, when the tribunal takes a decision, it usually splits the costs between the two parties and does not take into account who was the loser and who was the winner. And so that means that, let's say that if an investor, I'm taking an extreme example just to illustrate the point. So if an investor turns wrongfully against the host state, so if the investor turns against the host state, but the host state is totally innocent, then the host state in principle will still have to pay half of these legal costs. And so the EU proposal is for the loser pays principle, in which case the party that loses will pay the full amount. Of course, there are also arguments against the loser pays principle, and business may see it as disagreeable to them, because it will, of course, put them off initiating a case if they're uncertain to win, and so on. So I will try to sort of wrap it up and say that the European Union's investment policy is innovative for many reasons. I think the most basic of which I have covered. It is also likely to impact the negotiation of future investment agreements, because first of all, this was the point in transferring the competence from the member states to the European Union. The idea was, among others, that it's a different thing if the European Union is negotiating, let's say, with China, It's a different thing if, I don't know, Greece or Portugal are negotiating with China. So the idea is that the European Union would have more of an impact in investment negotiations. At the same time, the content of the EU investment policy ties in more with the new standards in investment protection. Traditionally, EU member states concluded their investment agreements with developing countries. So these agreements were one-sided because there was, let's say again, in the example, agreement between Germany and Mozambique. Germany would have an interest in protecting German investments in Mozambique, but there was never really a question of investments from Mozambique in Germany. So really the idea was to protect European investments abroad, and the developing country would have an interest in concluding the treaty so that it would signal to foreign investors that it was a safe destination and so that it would encourage incoming foreign investment. Things are different now because we have negotiations between developed countries. So the interest of the negotiating parties are different. So let's say in the past, typically the EU member state would have more negotiating power than the developing state, so it would be able to, for lack of a better word, let's say impose its investment model to the developing country. And this would mean a lot of protection for the investor, because the developed country, the EU member state, would not see itself as a likely defendant in an investment case. It would always be the other country that would be a defendant when a European investor would turn against it. With the new treaties, the situation is different because now we are negotiating, when I say we, the European Union is negotiating treaties with Canada, with the United States, with China. So there is a bilateral risk of violations. So it is not only now European investors that would turn against the US, Canada, or China, but there is a real risk that the other way around is going to also be the case. And so that means that the new treaties are more balanced in the sense that they don't only take into account the interests of the investors, but they also take into account the interest of the host state in protecting the public interest. And I think I have gone a bit fast because I thought I would not have enough time, so I'm going to finish 3 minutes early. Thank you very much.
Thank you. Thank you very much, Catherine. I think that we are going to give the floor to Fernando, and then at the end we can open the floor for debate and questions. So please take the floor.
Thank you. Hello, everyone. Thank you for being here. I would like to start by thanking the Rui Cunha Foundation, of course, as always, very receptive to this challenge, and also to Dr. Salles Marques for kindly accepting to moderate this event. Also to Catherine, of course, who readily accepted to come here and to discuss this very interesting topic. Interesting, at least from what I see it. Catherine has already touched upon and provided a very important background on several of the issues that are that underpin the European Union's common commercial policy after the Treaty of Lisbon, and she highlighted two very important dimensions: not only the treaty as such, the investment treaty, and the standards of protection that it normally includes foreign investors making an investment in a foreign state, but also the dispute resolution mechanism that is normally associated with these agreements, the infamous investor-state arbitration. These two dimensions, the substantive one and the procedural one, have been raising a lot of controversy for different reasons. As we all know, there is a growing anti-trade rhetoric in both sides of the Atlantic. For instance, in Europe, and very strongly in the US under the Trump administration. Over the last years, civil society organizations have also been mobilizing against agreements that Catherine has already mentioned, the CETA with Canada, the TTIP with the United States. One of the most important criticisms is targeted at an alleged lack of transparency of the negotiation process. So I'm not going to be talking about whether the accusations that there will be a lowering of labor conditions or a lowering of safety standards or other substantial criticisms. I'm going to focus on this alleged lack of transparency because I find it, I think that it is a very important question that is related to the legitimacy of the European Union at a moment of crisis. As we all know, the European Union is facing a legitimacy deficit, or at least a lot of people seem to think so. The problem starts because the European Commission, as you know, as we have already discussed, this is now a European Union's competence. The European Commission is the leading negotiator. So they will negotiate this agreement with its counterpart, for instance, with China. Those negotiations are taking place as we speak, after receiving a mandate from the European Council. That mandate basically issues some directives about what to negotiate. But then the negotiation will be conducted by the European Commission, DG Trade, the Directorate General for Trade. As Catherine also mentioned, a very important issue is that the last word belongs to the European Parliament. It is important to underline that. But that's another question. So the officials from the European Commission, they meet with counterparts, for instance, from the United States. And they meet in private. Of course, this doesn't happen live on Facebook or with open doors. The Commission has the obligation to report regularly to the European Parliament on the progress of the negotiations. And the final word, as Catherine pointed out, belongs to the Parliament. So the Parliament cannot suggest changes. It can also only accept or refuse the agreement. And this has happened before. It would not be the first time. This is an important question. This means that the last word is in the hands of the European Parliament, who is elected by citizens, differently from the European Commission. The fact is that the negotiation process is conducted by the European Commission. And this is only normal. Of course, you don't see national parliaments negotiating agreements. They send public officials who represent, in this case, the European Union. According to some, the fact that these negotiations take place behind closed doors is against democratic values. And this contributes to a loss of the citizens' confidence in the European policy-making process. When we talk about transparency, in these negotiations, we are essentially referring to access to documents. Civil society, for instance, wants to have access to what they are negotiating. We are essentially talking about negotiating documents, documents that the parties exchange, position papers where each one of the parties reflects on its own position, on its own opinion about how the agreement should be, and consolidated draft texts which merge the proposals from both parties after a round of negotiations. They are a draft, but they have been consolidated because they have been legally scrubbed by the parties after each round of negotiations. The problem is that not all of these documents are publicly available. We have different documents, different categories of documents. Public documents that anyone can access. You can find them in the European Commission's website, dedicated website to investment, trade and investment. Limited documents to which only people working on a specific issue have access, and restricted documents that can only be accessed by a very limited number of people. So a lot of people, civil society, political parties, believe that this is against the values of democracy because, as you see in this picture, the parties are negotiating behind closed doors, and for instance, the media and civil society organizations, NGOs, political parties, even national parliaments are kept in the dark. They don't have a clue of what's going on. So this, of course, when you throw this accusation of transparency, it means that it's a very easy way to cast a shadow of suspicion over the whole process. It's because they are cooking something. Who? The neoliberal interests behind the European Commission that wants to promote the interests of large companies, for instance. The question is that transparency in international diplomatic negotiations is a paradox, because there is no rule of public international law that prohibits confidential negotiations between governments. They take place all the time. Any book on the history of diplomacy talks about that. So the privacy of trade and investment agreements is also a time-honored practice. It has been around for a long time. The European Union has been describing the TTIP, particularly between the European Union and the United States, as the most transparent negotiations ever. However, the fact is that there is still considerable tension between the idea of confidentiality and this allegation of transparency. A key example of this is the negotiation mandate. When the European Council issued the negotiation mandate, the European Commission, this was made public immediately. There was a news report saying the European Council decided to issue a mandate authorizing the European Commission to conduct negotiations with the United States. But the full text was not released. As negotiations started, drawing public attention, a lot of people, including from the European Commission and the European Parliament and from civil society, started asking for the mandate to be declassified. They wanted to know exactly what issues were on the table. Actually, in 2014, a group of NGOs, including also journalists, submitted a request for access to several documents according to the European regulation on the right of European citizens or legal persons to access documents of European institutions. This request was rejected by the European Commission, saying that the publication of that information could weaken the negotiation position of the European Union, and it could compromise the interests of the European Union. The European Ombudsman at the time also decided to intervene, calling on the European Council, who had issued the mandate to release it, and calling on the European Commission to implement measures to increase transparency. Almost 1 year after the decision was made, the negotiation mandate was finally made public. And 1 day before, on the eve of a large protests in one German city against the TTIP. So this was a very important decision because it was the first time that this type of document was published. 1 month after the publication of the mandate, the European Commission published its transparency initiative, and it recognized that the negotiations with the United States had started on the wrong foot, that there was a lot of public interest, and so the European Commission didn't have anything to hide, and so they would implement new measures as part of a fresh start, and in order to win public trust and support. I'm quoting the European Commission. What measures were advanced? A very important one related to the European Parliament. Until then, documents relating to the negotiations were also only available to selected members of the European Parliament in a reading room, and they could not even take copies of those documents. And this brought about a lot of criticism. Now, all members of the European Parliament have access to those documents under strict conditions of confidentiality. Also, very importantly, from the perspective of civil society, the European Union started making available some negotiation texts and position papers. Of course, the position papers drafted by the European Union, because the United States do not apply the same standard. the United States are not facing of transparency. The United States are not facing so much, such a great backlash, at least from civil society. So this creates an imbalance. The European Union, before its own public, is being requested to be more transparent than the United States are. A second wave towards greater transparency came in 2015 when the European Union published its new trade and investment policy called Trade for All, towards a more responsible trade and investment policy. One of the main values behind this new strategy is transparency. So currently the European Commission's website makes available all of the negotiation texts and position papers chapter by chapter on the major negotiations that are underway. In the case of China, there is still not a lot of information available because negotiations are still in an early stage. So the question is, there was an evolution in the standard of transparency. Is this enough or not? Do we have enough transparency, or is it possible to raise the level? Some authors who are more optimistic argue that the record of transparency with regard to TTIP is quite unique, especially when compared with the one with CETA, because CETA was basically negotiated in the traditional way, behind closed doors. Also, the European Parliament has a greater involvement in the process. Of course, also for a question of legitimacy, of involving the European Parliament from the first moment, because they are the ones in the end who are going to approve it or not. And let us not forget that if the European Parliament feels a lot of pressure from civil society, they may feel compelled to reject the agreement. So the European Parliament is now a sort of co-negotiator. They don't negotiate directly, but they have the final word. So we can say from an optimist perspective that the level of transparency is already quite good. However, other authors argue that it's not enough, that this is a sham, that this is only window dressing, that yes, the European Commission released some documents, but they were available online anyway. I totally forgot about the pictures, and I want to give you something entertaining. These are some of some pictures that you can find online about this accusation of lack of transparency. This one, for instance, arguing that we are hiding the negotiation of this process because we are protecting the interests of large corporations. This is the European Commissioner for Trade, Cecilia Malmström, and she was the one giving she was the one behind the transparency initiative. I think she's a very it has her own personal touch. She's Swedish, so she emphasizes very often that Sweden is a very transparent country. This is the slide I wanted to show you. I would have showed it before if I was organized enough. There is this accusation that, the European Commission released a lot of information, but only because it was already available online anyway. Why? Because of leaks. This is also a part of the question, interestingly, because an author has coined the expression transleakancy, which is a mix between transparency and leakancy, and leaks, information leaks, in this case, the TTIP leaks. This means that even if it's not a formal, official, authorized source of information, information gets on the street. And this pushes the governments and the European Commission to come forth and release some information. So it's also a way to increase information. We can agree or not with this type of Dracula strategy of forcing the European Commission to face the light. The words are not mine. The expression Dracula strategy is not mine. But the idea is that civil society, by using the power of the internet, can also push towards greater transparency. My conclusions are the following. I believe personally that, I also suggest the same regarding investment arbitration. Transparency is not an absolute value. We don't have that many values in the field of law that are absolute, probably only life, but even in that case we have exceptions. And so, of course, access to information may sometimes be limited due to unjustified cases. For instance, to prevent the ultimate failure of negotiations. This has been mentioned by the former European Commissioner in the European Parliament. In national parliaments, you don't negotiate openly. Then the parliaments don't negotiate. Governments do, and officials don't negotiate live on the internet. Of course, if you negotiate, it's like if you do that, it's like playing a game of poker with your cards on the table. You need to advance a certain position so that you can bargain your way out. And very frequently, you reach to exactly what you anticipated in the beginning. You just played hard. That's the rules of the game. So sometimes it is necessary to protect legitimate interests. If you advance too much information in the beginning, this hampers the efficiency of the process. This may lead to a breakdown in negotiations and lack of trust between the parties. So, for instance, the European Union can only release the information which was created by the European Union. If it was created by the United States, of course, you don't reveal documents that the other party transmitted to you in confidence. This may lead to a loss of trust. So sometimes I think it's not really about confidentiality. It's more about privacy. Negotiators need to have a room where they can negotiate freely, openly, and keep the negotiation going, not create mistrust between the parties that you will spread around information. So negotiations need to be orderly in order to create confidence. We don't even need to talk about the value that in Asia, for instance, keeping face has. So negotiation between governments can never be fully transparent, or at least it cannot be fully transparent throughout the entire process. We need to have, we need to combine certain stages which are private, I'm not going to call them confidential, with other stages which are public. So depending on their timing and their sensitiveness. So this means that whenever possible, for instance, the leading negotiator should release the information, for instance, consolidated texts, as soon as they are available. But they don't need to do that in real time. So another round of negotiations took place. The parties advanced a next step. They closed a chapter. It's a draft text anyway, but they have moved on. Probably they can release some information regarding that stage. They don't need to leave that to the last minute. But asking negotiators to negotiate in a completely transparent manner is not realistic, in my opinion. Even the European Ombudsman, Emily O'Reilly, said when she notified the European Commission and the Council to increase transparency, that she agreed, and I'm quoting, that not all negotiating documents can be published. There needs to be room to negotiate. And the European Court, in Sophie In't Veld versus the Commission, actually she was a member of the European Parliament at the time, she requested access to 50 documents relating to the ACTA that would be later vetoed by the European Parliament, the anti-counterfeiting trade agreement. The General Court of the European Union held, and I'm quoting, "It cannot be denied that the negotiation of international agreements can justify, in order to ensure the effectiveness of the negotiations, a certain level of discretion to allow mutual trust between negotiators and the development of a free and effective discussion. As the Commission points out, any form of negotiation necessarily entails a number of tactical considerations of the negotiators, and the necessary cooperation between the parties depends to a large extent on the existence of a climate of mutual trust." So there are limits to transparency. Any negotiation process is a bargaining process. And so, of course, both parties are trying to bargain the best conditions, but they never show in advance what their real interest is. They go step by step and have some tactical considerations in their minds. In the words of the European Commission, you can find them in the website, the European Commission's Trade Commissioner claims getting TTIP right, in this case specifically TTIP, means listening to and involving everyone with a stake. And it means being as open as possible about what we are negotiating. However, the Commission adds, negotiations require trust, and that in turn requires some confidentiality. So certain texts we only show to governments and members of the European Parliament. Of course, that what I have been talking about external transparency in the sense of access of anyone, any of us, civil society in general, to the process. There is the other dimension that I'm not covering, which is transparency, internal transparency. I told you that the European Parliament has access to the documents, or to most of them. Of course, that the reasons behind the disclosure of certain documents to the general public are not the same as the ones behind the disclosure of documents to the European Parliament, because the members of the European Parliament, of course, have a right to know. And that right to know what is being negotiated has been expanded from the green room, the reading room model in the beginning, to a stage where any member of the European Parliament has access to most documents. So these two dimensions of transparency do not have the same weight. I believe that the European institutions have already achieved a sensible balance between a high level of transparency, while at the same time trying to avoid too much transparency that could affect the negotiation process negatively. We should also forget, and we should also not forget, and I mentioned this previously, that the final word belongs to the European Parliament. So if the European Parliament is deeply influenced by public opinion, and if there is a lot of public resistance to these agreements, members of the European Parliament may feel under pressure to reject this type of agreements. I mentioned this previously. This happened with the anti-counterfeiting agreement in 2012. And one of the reasons behind this was not so much substantial in the sense that it was that it affected the rights to privacy of citizens or protection of intellectual property rights. I'm not saying that it didn't. Was the lack of transparency. So the members of the parliament voted against the agreement, and it collapsed. In my opinion, the volume of information that is currently available on the TTIP has no parallel in previous negotiations. Of course, that this system can always be improved. It can also always be fine-tuned, but sometimes when we talk about when we have any discussion about transparency, we need to define exactly what we mean with transparency. And since, as I mentioned before, this is not an absolute value. This is a negotiation process. We should not forget that negotiators are politicians, that the European Commission is made of politicians. The European Parliament is also made of politicians. And of course, they also have their own considerations. That feeds into a different discussion about whether the European Union is guided by values or is just guided by trade concerns and trade and economic reasons. If it is a community of values or just an economic community, but that's a broader discussion. In my opinion, much of this debate that we are witnessing is not only about transparency in specifically the negotiation and the discussion of investment treaties. It is part of a larger discussion about the future of the European Union, about how connected people feel, European citizens feel with the European Parliament, and about whether there is a disconnection and a democratic deficit in the European Union institutions. I believe, honestly, I have probably been accused of being too naive. I remember when we were in the European Parliament discussing these topics, I remember someone mentioned that the European Commissioner for Trade would like to hear the leading negotiator, Barcelo, would like to hear my words because I was too pro-Commission. It's not a question of trying to justify what the European Commission is doing. I believe that you need to compromise. I believe that transparency is not an absolute value, that this is a negotiation process, and it is a political process. Let's not forget about that. The same applies to dispute resolution. The system is evolving and reforming in order to survive. The European Commission, of course, knows that if this process is made against people and doesn't involve citizens, it will collapse anyway. So we can discuss if this transparency is enough or not. I argue that it is a step in the right direction and that it is not possible to have full disclosure all of the time of this process. Thank you very much for your attention.
Thank you very much. So I would like to open the floor for questions, comments. Would you like to make some comments, cross comments?
I did have some thoughts that came up as Fernando was presenting, and I totally agree actually about what you said, that transparency cannot be an absolute value. And what I thought was that in Germany, Germany negotiated the first investment treaty with Pakistan in 1959, and since then Germany has been the biggest investment negotiator with more than 100 bilateral investment treaties. And the German public never cared about the content of German bilateral investment treaties. But as soon as the competence passed to the European Union, suddenly the German public started not to like the conclusion and the negotiation of agreements by the European Union. The German Association of Magistrates said that you can't have investor-state dispute settlement in EU investment agreements because A, B, C, D. All these reasons were there since almost 1959, but no one had bothered with them. So I think a lot of the criticism that has been addressed to investment agreements, and now I'm speaking of the treaties as investment agreements, so if I'm thinking of TTIP, I'm thinking of the investment chapter. I don't have the competence to talk about the other chapters, but I'm thinking about the investment chapter, and it's the investment chapter to a large extent that has attracted the criticism that there is a lot of misinformation that makes people think that these are bad agreements. So I remember I was sent at some stage an email, one of these forwarded emails, that was full of criticisms for TTIP. And I'm sorry, I've moved a bit on from transparency. Just one thing led to the other, but I will have finished in 1 minute. This document was full of misinformation. It said, for instance, TTIP will have a negative impact on developing countries. Well, TTIP has nothing to do with developing countries. It's a treaty negotiated between the EU and the US. It also said, I think the point was it's very bad, investment law is bad for developing countries. So it also said that Philip Morris, the investment law regime is turned against developing countries. See, Philip Morris has a case against Uruguay because Uruguay tried to pass legislation for the public health. Yes, but how about the case against Australia at the same time? On French TV, on the news, national French TV, when CETA was, when the parliament, the local parliament in Brussels was not happy with CETA, so on French TV they had invited an expert who said that CETA is not liked because it contains investment arbitration. Well, wrong. The CETA contains an investment court. It does not contain investment arbitration. I'm saying all this to show that transparency also leads to misinformation, because it leads to people who did not have... I mean, investment law remains a specialized field of public international law. So if a treaty says the treaty grants fair and equitable treatment, to understand what it means, you have to know how fair and equitable treatment has been interpreted. You have to know what lies behind the words. And so it may be deceptively simple to just interpret everything one sees, in the same way that I'm not trying to interpret the different chapters of TTIP and the other investment agreements.
Okay, thank you.
I'll leave the floor.
Portuguese relation with historical countries like Brazil, Angola, Mozambique. If I want to, as a Portuguese, want to do an investment on those countries, still has to go through the European Union?
Okay, so
Professor Catherine.
thank you. So we're in a transitional period, and there is a regulation that says that EU member states, when they want to negotiate an investment treaty, and the EU at the same time does not plan to negotiate an investment treaty with a said country, they can ask authorization to negotiate. So in fact, EU member states can still negotiate investment treaties, but they need to ask for the authorization of the EU before doing that.
Good evening. I just would like to, one question for Professor Fernando Simões. I understand that transparency is difficult on these kind of negotiations because nobody wants to be negotiating under pressure and under the scrutiny of public opinion, often in matters that sometimes are so technical that the common people don't even understand what is being discussed. But my question is, I suppose, and it's somewhat the my assumption that this confidentiality is during the process of negotiation and it continues after the process of negotiation. No?
No, there is a final proposal that that will be made public, and that, I mean, the agreement is not signed by the European Commission, by the Council on behalf of the European Union. Under secrecy, it will be the text will be revealed in the end.
Yes, the text, the result of the negotiation, yeah. But I mean the document and the negotiation itself. Yeah. Is it public after the document is reached or not? Because my question, the question that I want to pose is this: would not the fact that after reaching the agreement, everything that preceded the agreement, yeah, will be public, will not be a solution to this transparency concerns? It's my question.
Imagine that the European Union had been advocating for a certain starting position. That position was kept confidential. Then the United States made a counter proposal. They negotiated, they discussed, they reached a compromise. They have a consolidated text that merges the clauses after they were worked out by the parties, and then they released that part. We finished the chapter on intellectual property rights. Here it is for public discussion. They will probably never reveal the original position of the European Union. Otherwise, there will be public criticism. For instance, the European Union gave in its position. Probably in exchange for something. That's negotiation. So you will never be. I think the European Commission mentioned, the Director General for Trade, that some of those documents regarding the negotiations can remain confidential for decades. That has to do with not fragilizing not losing face for any of the parties. If you know that every time you cede on a certain point so as to gain an advantage on another, like trading chip, that could be used against you, because European citizens, for instance, would know that the European Union had a very high standard or a very high initial position, and then decided to lower in exchange for conditions on another topic. So what I was referring to is that whenever possible, disclose the information. And whenever possible, do it timely, in the sense of you finished a chapter, why wait for the whole document, the whole agreement to be finalized in order to release it? No, release it drop by drop as it becomes available readily. Then the text is available, for instance, even before the final legal scrubbing that takes like 1 year. The TTIP is available, and it's not
even
fine.
a proposal.
Yeah,
it's not
the legal scrubbing is just a matter of detail. Lawyers, of course, they go through the text. They need to translate it into all official languages, but it's available online already. The case of the TTIP, we don't know if it's going ahead or not. But what I mean is, whenever possible, if you don't have anything else to hide, make it public. Allow for discussion. Otherwise, you don't give enough people enough time for the European Parliament to consider the agreement and for public opinion to have access to the agreement. Also to allay some fears that very frequently are not founded. Sometimes I also wanted to add that it's interesting to notice, and there was some news reports on that earlier, the NGOs have never raised so much money as currently. Why? Because this is mobilizing a lot of people. So it's kind of ironic. If they kill the TTIP and the similar types of agreements, they will be out of business. Because once this is over and there are no more treaties to negotiate, they will not be able to raise so much, to raise so much funding and to employ so many people, legal counsel and people who are professionally working, lobbying politicians and members of the European Parliament against the agreement. And we should also take into account that even if most people consider an agreement to be excellent or very reasonable or very good, there will always be people opposing free trade. Why? Because free trade and investment policies are political options. The European Commission believes that this is good to increase employment, to improve the economic situation of the European Union, to expand markets, of course, and that it is possible to balance economic development and sustainable development and environmental protection, public health. Some people deeply believe, and they are legitimately so, that free trade is only the new face of globalization, that it is a new type of colonialism. It has been branded like that by some people. So some people will always oppose this type of agreements because that's their political belief. Just like the European Commission is led by political intentions. Of course, they are politicians. We should not forget that. They are not just technicians who... The only technicians in the process are the negotiators and those who will comment later on the agreement.
Just a follow-up question precisely on that part. The reverse side of that level of confidentiality is that in the eventual dispute resolution, if we need to know what was the intention of the parties, where the parties concede, it would be important to know if one party actually conceded in order to achieve a certain result and the other party is actually taking advantage of the result of the text that somehow can be poor in order to not express precisely what the parties wanted. This usually happens. Yeah, and this level of confidentiality of this documentation may put in jeopardy justice in this type of dispute resolutions.
That's a very, very, very good question. Thanks. I don't know if you want to...
If I may, I was also thinking, as you were talking, how much are we scrutinizing national parliaments? And I think it's also a question of trust. I think you mentioned trust at the beginning. Also, as you mentioned, transparency concerns transparency of negotiations, also transparency of investor-state dispute settlement, so investment arbitration. And so in investment arbitration, we have now a much more transparent process than we had. And there have even been hearings that were filmed. And so apparently, I don't know if they put them on YouTube or there was something. And I was told, I don't remember the numbers, but for the first one, there were, I don't know, thousands of people who clicked on the link. And then for the next ones, it just went because people are not really interested in.
You cannot throw that card away.
Yeah, and just a final thing that also concerning investment negotiations, we have generally states have models, investment treaty models that they make available, and so the investment treaty model shows what they wish to include in the agreement. The European usually states develop model agreements some years after they start negotiating treaties, because at the beginning they're really discovering what they want. So the European Union does not have a model agreement. Some states never do. But in reality, the European Union has been publicizing what it wishes to be the content of its treaties, and every time, generally, the latest treaty it shows where the trend is going, where the European Union wants to go. So I think also this mitigates the perception of lack of transparency, because there is usually some text available out there that shows the tendency.
Let me just add something. That's a very interesting question, and it relates to something that, besides this effort towards greater transparency, the European Union also conducts the so-called sustainability impact assessment of trade policy. So this is a study conducted by external consultants, and they are supposed to analyze the quantitative and qualitative positive and negative consequences of free trade agreements, and they consult civil society, and they are conducting, for instance, as we speak, they are conducting a similar study regarding the BIT between China and the European Union. And it has been argued, for instance, that the precise conclusions of that document, that is not binding on the European Commission, they may decide that's not what we want, and this is a political decision. There have been some authors arguing that this could be an interpretative input, that we can use the trade, the sustainability impact assessment to argue this is what the parties really wanted when they use this expression. It comes from the travail préparatoire. My French is non-existent. But that we can resort to that type of interpretative argument. And we could argue the same regarding those documents. First, I would say, the lawyers representing the parties would always have access to them. A lot of the things that happen, even in arbitration, that are confidential, a lot of awards circulate among the professionals. They may not be publicly disclosed, but people, lawyers, arbitrators, professors know about their existence and they share them. So they will get them, they would get them anyway. Even if they do, I'm not really sure about the value, the binding value of such statements, because they are negotiating positions. Of course, as a lawyer, as you know, you would make the strong case that this is what the European Union and the US had in mind when they used the expression whatever. But the arbitrators would not be bound in any way by that interpretation. It's just another element. But it can be, an author has argued, regarding the sustainability impact assessment studies, and I think it can extend to that case. It can be used as an interpretative argument, but it is not, just like the preambles normally are just statements without any legal binding value, the same would happen in this case. But of course it contributes to know the history of the agreement. Maybe scholars will pick it up. Yeah, but it's always a draft. Yeah, until it becomes the final text, it's always a draft. So we can consult in Portugal, for instance, we can consult the discussions in the parliament, and frequently we do that if we want to advance a certain argument, saying in this discussion they use the word whatever. It's published in I don't remember the name of the official of the bulletin that publishes the acta from the Assembleia da República, exatamente. It has the value that it has. It's not binding. But it's, of course, it can be sometimes a very strong argument. But I'm not really convinced that arbitrators focus mostly on the black letter law of the agreement. So that would be an historic element that could be taken into account or not.
Well, I have a question for Catherine. Since Fernando mentioned about the BIT with China, Well, the BIT will go through all the procedures. Of course, the European Parliament will have last say in regard to his approval or not. So at this moment in time, and as the negotiations has not been very transparent, at least there's not too much that we know about it. Is there anything that you could say about the process and what to expect in the future?
Thank you. I would not really say what to expect, apart from maybe some general things. For one thing, content-wise, I think the European Union is interested in including a national treatment for the pre-establishment stage. So one of the elements that have been described as creating problems for European investors who want to invest in China is that they don't have access to the Chinese market, so that the market is closed. And so I think that also following the same policy that the EU is following in its other treaties, that one of the intentions is to convince, and maybe one of the points where there are some doubts whether the EU will convince China is to include, to give national treatment at this stage, so to treat all investors, domestic, so Chinese as foreign EU investors, in the same way. And maybe the other general statement is that the EU, for the time being, seems to want to include a court in its future investment agreements. Having said that, the public consultation of the EU that was, I think, in March 2017, had one question, which was, there were questions about the usefulness of the court, the usefulness of establishing a multilateral investment court, but they also had some questions that were considering the possibility of having an appellate mechanism. So they seem to be, this was for the multilateral setting. I'm just wondering if that also doesn't mean that there's a small possibility that the EU will not necessarily insist on that. But I would say that the intention is to also include a court in the EU-China agreement. And I think I was told that China is not unhappy with that, that maybe China will.
Because it is institutionalized, and that's something that China prefers in the field of arbitration. Not ad hoc. So that can, I agree that China may be interested in having a more stabilized court with full-time tenured judges instead of ad hoc arbitrators.
Okay. Well, any more questions or comments? Otherwise, we are about time. So thank you very much, Catherine and Fernando. And thank you very much for being here today. Thank you.